What are some of the top trial strategies in handling a Jones Act case when presenting it to a jury? My name is Tim Young. I'm a maritime attorney, and we've tried dozens and dozens of maritime injury cases over the years. I want to discuss with you briefly 3 top ideas that we find work very well when presenting a Jones Act case to a jury. The first idea is for the jury to understand that it's an employer relationship that you have with the defendant. This is very important because they need to understand that you've probably worked very hard for your company over the years. You've made your company a lot of money, and now unfortunately you have to be in court seeking money from them. Once a jury understands that the company has benefited from your relationship with them over the years, sometimes it's easier for them to understand what you're going through, and sometimes it's easier for a jury to find your company at fault for not doing what it should have done. The second top strategy we find when trying cases with juries is to really help them understand that you're not going to get any type of a lottery win out of any type of a verdict or an award they may make to you. I tell juries it's an award, it's not a reward. And the difference is nowadays a lot of juries think that you're coming into court and anything they give you is going to be a windfall. We really walk the jury through to understand that all they are trying to do is put you back into the same place you would have been had it not been for your injury. A lot of times this includes simply giving you the past wages that you would have made. It simply includes giving you future money that you're unfortunately not going to be able to make. Again, none of this builds you up or makes you any better. It simply puts you back to where you would have been had your company or a third party not done something wrong. This can be very powerful for a jury to understand because then they feel like they're just righting the scales rather than giving you some big reward in the case where you're going to actually be happy at the end of the trial. All you want is fair compensation, and the jury has to understand that. One of the third tips we find when trying cases to juries relates to a company breaking their own rules. The main thing that juries can understand, is if a company has written out rules, their own rules, and they're not following them, it's pretty easy for those juries to find the company at fault. We always go through safety manuals. We always try to point out when a company is not following its own rules. The company will try to put you on trial, and the purpose of your trial is to shift that back to the company and show to the jury what they may have done to cause or contribute to your injury. Those are some of the top trial strategies that we find juries really connect with and understand, particularly the employment relationship. Remember, most jurors are going to have an employer, so they're going to understand what you're going through, and they usually put a pretty heavy burden on an employer because they know, like you, that they have to go to work and work for somebody every day.